We all be seated. Right, the record can reflect we're back in the courtroom outside the presence of the jury. Right, you able to go through the instructions right now?
Well, Your Honor, I think we can tell you a few things about the instructions, but there is one addition Mr. Bednarik wanted to make that he said he filed a motion on that I haven't seen yet, so that we might save for the end of the day.
So let me just explain, Judge. I think, and I don't want to speak out of school, but I think that the state and the defense are, 95% in agreement with the instructions that you have prepared.
If they need to still be adjusted, there's some things that need to come out. I understand that. I'll take out the things that are totally irrelevant. And we can get through that real quickly. I'll take 2 minutes, I think.
Right. The only bone of contention, I think, between the state and the defense is whether or not 517, which is a unanimity instruction, should be given. The state, I believe, takes the position that it should not. The defense is of the position that it should be. Over the lunch hour, I had our research and writing specialist in the office file a memo in support of 517. It was electronically filed over the lunch hour. Because of how the electronic filing system works, I didn't see that, so it was docketed yet, and that's understandable because it was just filed a half an hour ago. My point in making the statement is that I think the only substantial argument that we have is whether or not the court should or should not read 517.
Okay. Now let's go through the other instructions then real quick so I can edit those down, and then I will look at that between now and our next instruction conference, all right? I'm going through. Do I see a issue? I guess page 5, if you have that, agreed testimony. I don't know if I need to say anything about that. You've had a lot of stipulations here. I can give that. The way I wrote it says that you have stipulated or agreed to the admissibility of evidence consisting of lab reports, photographs, recordings, and other evidence, and I guess in effect, perhaps testimony, but I think it's like Captain Zimmerman relating a lab reports. But the way that's written, is that all right?
It is with me, Judge.
And that's, to be clear, reference to 161 agreed testimony?
That's correct?
That's fine with me.
Okay, I will highlight that then for the next version. Agreed facts, I don't know that I need to worry about that. There's really no agreed facts, is that right?
I don't think so, Judge.
Correct.
Okay, I'll take that out. Judicially noticed facts, I don't recall noticing anything, right?
Correct.
Agreed.
Okay. I do have 201 there, opinion of a non-expert. I don't know that any of the officers really rendered any lay opinion. I think one of the experts may have given a lay opinion through the testimony at one point, but
Judge, I'm not asking for 201. I don't think that we could identify a witness with an opinion, so I'm not requesting 201.
you agree?
Agreed.
Okay. I have 154 on page 9, summary of evidence that was requested by someone. I don't know, do you really have a chart?
No, Judge, we've agreed that I think we don't need 154.
You agree?
I agree. The summaries that'll be put in are different types of summaries.
They're the PowerPoints, basically, right?
Well, and there'll be summaries of voluminous records, but 154 contemplates a different type of summary. Mr. Grinke and I discussed that the summaries, and I'm using air quotes now, that we're putting in aren't summaries as contemplated by 154. They're
That's
just
fine.
any other piece of evidence, so no 154.
I assume both of you will indicate that what you're doing is a summary, right, when you talk about it?
Yes, Judge.
Okay, I'll take that out. I haven't struck any testimony yet. I'll take that out at the end if I haven't. Nobody's asked for that.
Correct.
300 I left in now that Mr. Kendhammer has testified, so I highlighted that. And I took out, I think it's 315. That usually would follow that if he did not.
Correct.
So that takes us up to the closing arguments, and then the last instructions, I think, were okay the way they are, correct?
Yes, Judge.
Yes, and then the only remaining issue then appears to be whether or not we should or should not read 517.
Okay.
Your Honor, also there was one other one. I'm sorry I didn't mention this before, but 152 is the instruction for the view of the scene.
I gave that already. You want me to give that again?
I don't, Your Honor, it's contemplated that it could be given at the end if the defense wanted it. There's a modification in the notes as to basically the last two paragraphs. I wouldn't object if the defense wanted it. I just wanted to raise that as an option.
I could, in conjunction with what evidences indicate that the view of the scene was not evidence, and just give those two paragraphs there if the defense wants that.
In the notes, it says, it makes sense. It basically says going to the scene was to help understand the evidence. It is not evidence, words of that effect. If the defense requested it, I wouldn't object.
I don't think it's necessary. They've already been instructed on that, Judge.
Okay, I will not add that, but I'll look at 517. I'll probably put that in the next draft to you with the other changes, and we'll talk about that then at that point.
Thank you.
Anything else?
No, Your Honor.
No.
If they're ready, you can bring the jury in. All right, you may all be seated. Hey, Captain Zimmerman, I think you were subject to cross. Were you going to cross him?
Your Honor, I had no questions, so only if the juror had questions would he need to take a stand again.
Well, any juror think they have a question of Captain Zimmerman from his testimony that he just gave this morning? I don't see any hands. All right. You have your next witness ready?
Yes, I call Siobhan Cagle.
Perjury, do solemnly, sincerely, and truly declare and affirm that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth.
Will you state your name, spell your last name for the reporter, please?
Siobhan Cagle, SHAVON CAYGILL,
And how are you employed?
with Hurley Bursch and Stanton as a paralegal,
For how long have you done that?
11 and a half years.
And what are your duties entail?
I do a lot of trial preparation, discovery management, and I assist the attorneys with the different cases we're assigned.
In connection with your duties in this matter, have I asked you to prepare some summaries?
Yes.
Your Honor, I'm going to question Ms. Cagle about Exhibits 278 through 281, summaries of phone calls prepared by her, and I believe we have state and the defense have reached a stipulation as to their admissibility.
Is that correct?
Yes, Your Honor.
Right. I guess I will receive 278, 279, 280, and 281 then, and you can proceed.
May I publish, Your Honor?
If you wish, go ahead.
Ms. Cagle. During the pretrial process in this matter, did you have occasion to review telephone records of Todd and Barbara Kendhammer?
I did.
And did I ask you to prepare summaries of text messages from those telephone records?
You did.
I'm going to show you what has been marked as Exhibit 278. Can you tell the jury what this is?
This is a summary of ingoing and outgoing text messages between Todd and Barb Kendhammer from September 14th through September 15th. And I took this from Todd's cell phone records, extraction report.
And just so the jury has some notion about how many pages were the telephone records of the Kendhammers?
Over 500 each.
If you would, could you take them through the content of this summary?
Sure, it starts on September 14th at 6:33 a.m. and it's a message from Barb to Todd saying, "I love you too, love you too." Todd responds, "Love you too." At 2:11, Todd texts Barb, says, "How was your day?" 2:14, Barb responds, "Okay, how's yours going?" She responds back, "Okay." At 2:26, Barb sends a message to Todd saying, should I start to mow the lawn tonight or tomorrow night? You could finish it Friday. 2:28, he says, you can start tonight if you want. She writes back and says, okay. At 6:30 a.m. on Thursday, September 15th, Todd texts Barb, love you too, good day. She texts back, love you too, have a good day. There was a text at 10:21 a.m. saying my check is $623, no worries. That same text is at 10:21. For some reason, some of Todd's text messages they would be duplicate, but I put them all in. 2 o'clock that day, there was a text to Barb saying, hi, how was your day? Call me before you go home. And that's a duplicate as well. Barb texts him at 2:22 on the 15th and says, did you find anything out about Mom's pump? She's asking. He writes back and says, yes, I have someone coming tomorrow. She says, okay. And there's a text at 3:15 saying, nice. And where's that from?
Did you also have occasion to prepare a summary of incoming and outgoing texts between Todd Kendhammer and Michael Service, his son-in-law?
I did.
I'm going to put Exhibit 279 on the screen. Will you tell the jury what's in that summary?
Sure, again, I started on the 14th of September, and it was 2:22 p.m. Todd texts Michael and says, what'd you find out about my pump? He texts back and says, no check valve on pump. And again, Michael texts Todd and says, Shannon says you should probably get a well guy there and update the system. Later, on the morning of the 15th, Michael sends a text to Todd saying, can you put the keys in the Tahoe? Todd writes to Michael, what time are you gonna get it? And there's a duplicate. And then Michael writes to Todd now, and then he writes again to Todd saying, I'm going to have to do it in the morning. I'm going to have to do it tomorrow. I forgot that I never put the battery on the battery charger on the battery. And then he writes, they're open until 4 p.m. tomorrow, so I will get it during work sometime. Michael then texts him at 5:25 that night, says, can you go to my house after work and hang the drywall on edges so Jamie can put corner bead on it? I have class till 9 and I can't make noise when I get home. Todd texts back, says, can I do it in the morning? Michael texts back and says, I'm sorry, there's a duplicate. And then Michael texts back, I'll do it tonight if you can't get there, it's no big deal. And then at 8:33, Michael texts Todd, thank you for stopping over. I put the other piece on by the back door real quick. Then we go into September 16th at 6:48 a.m. Michael texts Todd, I'll try to get to your work today to pick the Tahoe up today because we need to get the carpet and flooring this weekend. Todd texts Michael, I don't work today. I will dump it. Did you go pay for the flooring? And it's a duplicate. And then the last text was at 7:09 that says, I'll call you soon.
And that text was from whom to whom?
I'm sorry, that was from Michael to Todd.
Did I ask you to examine the telephone records and the extraction report to determine calls made between Todd Kendhammer and Joyce Adams?
You did.
I'll show you exhibit number 280. Can you tell the jury what you did to arrive at this?
Through Todd's cell phone records, I counted from March until September 16th, the day of, how many times Joyce has called Todd or Todd has called Joyce. And what I found was there were 65 phone calls from Joyce to Todd in that time frame, and 238 phone calls from Todd to Joyce in that time frame, accounting for 303 phone calls between Todd and his mother-in-law.
Now, did I ask you to examine the phone records to determine if there were occasions when Barbara Kendhammer did not call her mother, Joyce Adams?
You did?
I'll show you what's been marked as exhibit number 281. Can you explain to the jury what this summary shows?
Sure. I went back through the phone records and I took a calendar and I marked every day that Barb had not called her mother, and I counted them up. So in September, she didn't call her mother 4 times. In August, she didn't call her mother 6 different days. In July, it was 6 different days. And in June, it was 6 different days.
Judge, my next questions will pertain to exhibits 285 through 290. These are the transcripts of it.
Okay.
And the state and the defense have reached an agreement that these may be received into evidence.
Is that correct?
Yes, Your Honor.
285, 286, 287, 288, 289, and 290 will be received.
Ms. Cagle, can you tell the jury what exhibit 285 is, please?
Sure. It's the first 911 call on September 16th, 2016.
Well, is it the call or is it,
I'm sorry, it's the transcript of the phone call.
and by whom was that transcript prepared?
I received it from the state.
What is exhibit number 286?
It's a transcript of the second 911 call on September 16th, 2016.
And by whom was that prepared?
The state.
And what is exhibit 287?
That is a transcript of Officer Leffelholt's squad interview with Todd.
And who prepared that?
A company called Verbatim in Madison.
And is Verbatim a transcription company?
It is.
Did you request Verbatim transcription to take the tape recording of that interview and to transcribe it?
I did.
And did you have an opportunity to compare the transcription against the tape recording?
I did.
And except where the transcript says inaudible or unintelligible, is it an accurate transcription of the tape recording?
Yes.
Exhibit 288, what is that?
It's the recorded interview of Todd Kendhammer at the La Crosse County Sheriff's Department.
And by whom was that prepared?
It was prepared by Verbatim in Madison.
The same transcription company?
It was.
Did you also make a similar comparison of the two?
I did.
And except for where it says unintelligible or inaudible, is it an accurate transcription of the recording?
Yes.
Next exhibit is which number?
289.
And what is that?
It's a transcript of Officer Wickland's squad car video with Todd Kendhammer.
And by whom was that prepared?
Verbatim.
And did you have an opportunity to compare this transcript against the recording?
I did.
And once again, except where it indicates that it's inaudible or unintelligible, does it appear to be an accurate transcription
Yes.
of the recording? And what is the final one?
290.
And what is exhibit 290?
It's a transcript of Todd Kendhammer's interview with Mark Yaley on the way to the hospital.
And by whom was that prepared?
The state.
Did you have an opportunity to compare that transcription against the original?
I did.
And again, except where words were inaudible or unintelligible, does it appear to be an accurate transcription?
It does.
283 and 4 are the numbers.
Okay.
284, the small one, 283, the attempted large.
Okay.
Your Honor, the next two exhibits are 283 and 284. I believe the state and defense have reached an agreement that these may be received in evidence.
Is that correct?
Yes, Your Honor.
283, 284 will be received?
In the course of your duties with respect to this case, did I ask you to review the videotape of the camera that was at the Wild Winds?
Yes, you did.
And did you do that?
I did.
How many times did you do that?
More than 50 times, but I would say it's probably even more than that because I went individually with each of the cars. I'd rewind and go back and rewind, pause, go back for each of the cars.
What is the difficulty that you had in viewing this vehicle?
The distance of the camera to the highway. It's very hard to see the images and they go by pretty fast. So to make out the image, you have to really watch it again and again and again.
And did there come a time when you thought it would be helpful to get assistance in doing this?
I did.
And what did you do to get assistance?
I took it to a media place in Madison called Entail Media and asked them to try to freeze the frames or sharpen the frames or blow up the frames to get a better image of the vehicles.
Did it turn out that this worked just exactly like it does in television and the movies?
No.
What happened?
When they tried to get clearer images or zoom in, it just made it grainier so that you can't, makes the vehicles almost like you can't even tell that it's a vehicle anymore.
I have exhibits 284 and 283. Are you familiar with these?
I am,
And are these screenshots from the video?
yes.
I'm going to show you exhibit 284. Do you recognize that?
I do.
And what is that?
It's a still of the video. I think it's at it say 1957-22. And if you can,
It-
I'm sorry.
What I'd like you to do, Ms. Cagle, is if you would take the pointer and use it to show the jury where in the still it is that, let me rephrase it. If you would show the jury where in the video it is that one might see vehicles passing by. So it's right along there, and in the center of where you moved the laser pointer, and to the right of what appears to be a trailer in the foreground, is there a triangular shaped, what would appear to be a conifer or fir tree?
Yes.
Now, I'm going to show you what's been marked as Exhibit 283. What is 283?
It's a blow up of the previous image.
And is this of considerably less resolution than the prior
Yeah.
image? Now here, when you use the pointer in that area where on the video one could see traffic passing by, that area is now larger. Is
Yes.
that correct?
Yes.
But is the definition less?
Yes.
And is that what the problem was in trying to enlarge it?
Yes.
So in enlarging the images from the video, was that helpful?
No.
In watching the video over and over, were you able to discern at times whether some vehicles were larger than others?
Yes.
Were there times that you could discern whether some vehicles were darker in color than others?
Yes.
Were you ever able to discern that a vehicle was instead of my asking, tell the jury what you were able to see with any degree of certainty.
I couldn't tell you with any degree of certainty what each vehicle was. I can tell you, I viewed vehicles going northbound and southbound. I could tell some vehicles are larger, or some looked like a car, or a bigger vehicle, which you would assume was a truck. But I couldn't tell you what each of those trucks were, or if they make out if it was a flatbed or not a flatbed, or what kind of bed the truck had.
I believe that's all the questions I have. Thank you very much.
Thank you, Mr. Hurley. Mr. Brink, are you going to
Yes.
across, right?
Sure. You want the charts? Sure. All of these? Do you want the images too? Okay.
Ms. Cagle, I'm going to start with showing you Exhibit 278. And it's a multiple page exhibit, so I'm just going to skip to the second page of it. You said there was a text from Todd to Barbara Kendhammer, October 15th, 10:21, and it says, "My check is 623, no worries."
Yes,
Do you know what check that was referring to?
I don't. I believe that there's another text that would have been an image text.
And that's not listed on this?
It's not.
Was it in this time frame?
I believe that you guys put in here something about a text that was an image text. Am I wrong?
Well, let me ask it this way. When it says 10:21, there was a text from Todd to Barbara, was there any call or text from Barbara to Todd around that time that would explain what that was?
There could be.
Does that mean that this chart doesn't include all the text messages between Todd and Barb?
I believe it includes the text messages in that portion of it. There could be some image text messages that didn't come out in the extraction report that are not included in here.
I see. Okay. Then on the last page of that exhibit, in the afternoon, 3:15, it looks like there was a text from Barb to Todd, and it just said "nice" with exclamation points.
Correct.
Do you remember testimony from Todd Kendhammer that was in regards to the porta potty bill?
I do.
And did you see the image that was attached to this text?
I did see that.
Was it a note that was basically a bill from Best Kept Portables?
Yes.
And the response from Todd to Barb was, where that from?
Yes.
The other question I have is on Exhibit 281. And I just want to clear up in case I have some confusion. It said on the right, it says number of times in a month Barb did not call Joyce. Does that mean the entire day there was no call? Is that what those numbers represent?
Yes.
So for 4 days in September, all day long, there was no call from Barb to Joyce?
Yes.
Because the state had showed an exhibit of some calls that indicated that calls in the morning. Do you remember that?
Uh-huh.
Exhibit 48.
I do.
And there were 5 days, Saturday, Sunday, and Labor Day, there were no calls in the morning. There were 5 days, you indicate 4. Does that mean on one of those days in the afternoon or night later on, there may have been a call that you counted?
In September, I counted 4 days that there was no phone call,
All day long?
all day long.
Okay, so this wasn't reference to the morning calls on our way to work or anything like that?
Correct.
And that included, these numbers would include weekends?
They do include weekends. They're not
Every day.
all weekend.
Okay. And And then just regarding the photos that you were showed from the video, we don't have to look at the video, but you indicated that the vehicle that you saw driving southbound was at 7:57 and 22 or 23 seconds.
Correct, for
And-
that image.
And you also did a timeline indicating when other vehicles drove by. Do you remember doing that?
I do.
What was identified as a Kendhammer vehicle was driving northbound at 7:57 and 13 seconds. Do you remember that?
That you guys identified it as the Kendhammer vehicle, yes.
The possible Kendhammer vehicle, right?
Yes.
So if that was a Kendhammer vehicle going north at 7:57:13, this vehicle that was going south was only 10 seconds later.
The image that was shown to show his point of blowing it up was 10 seconds later, yes.
And then the next time that you saw anything going southbound was a van and a car, both at about 7:58 a.m.
I would have to look at my notes, but I believe, I mean, if you're looking at it, then I'm sure that you're right.
Okay. Those are all the questions I have. Thank you.
Anything else, Mr. Hurley?
No, sir.
All right, at this time, does any juror have a question? Ms. Cahill, at least one? Okay. All right, Ms. Cahill. Question number 537 is the days between June through September when Barb did not call her mother. Was this the total of these days? What is the total of these days that fell on a weekend or a holiday?
I can't say for sure. I could look at my notes.
You have them with you?
I have them at my desk. In September, she didn't call her on Saturday, September 3rd, Monday, September 5th. I do believe that was probably Labor Day weekend. Didn't call Saturday the 10th, and then the 6th, I didn't include the 16th. In August, she didn't call her on Monday the 8th, Tuesday the 9th, Friday the 19th, Sunday the 21st, and Friday the 26th. In July, she didn't call her on Thursday the 7th, Sunday the 10th, Saturday the 16th, Sunday the 24th, Saturday the 30th, and Sunday the 31st. In June, she didn't call her on Saturday the 4th, Monday the 6th, Tuesday the 14th, Thursday the 16th, Friday the 17th, Saturday the 18th, and that's it.
Thank you. Question labeled 538 is as follows. Was there a record of Joyce Adams' calls to Barbara Kendhammer that complemented the record of calls from Barbara to Joyce?
I didn't have access to Joyce Adams' phone records.
Okay. Right, thank you. All right. Are these all my exhibits?
Yes.
Okay, can you step down?
Kendhammer called Jessica's service.
Under penalty of perjury, do you solemnly, sincerely, and truly declare and affirm that the testimony about to give in this matter are the truth, the whole truth, and nothing but the truth?
Good afternoon, Ms. Service.
Good afternoon.
Could you please state and spell your name for the court reporter?
Jessica Service, Servivais.
How old are you, Ms. Service?
25,
Makes you born in what year?
1992.
And where would you say that you're from?
I'm from West Salem.
Your whole life?
Yes.
Where'd you live in West Salem?
We lived in town for a while, in the country in a while, and then we kind of switched back and forth because my mom liked to switch it up every couple years.
We'll get to your relationship with your husband and living with him, but when you lived with Todd and Barbara Kendhammer, who are your parents, yes?
Mm-hmm. Yes.
For the last 10 years or so of living with them, where was that residence?
East Scotch Cooley Road in the country.
Did you live at that residence throughout high school,
Yes.
middle school as well?
Yes.
You have a brother,
Yes.
Jordan,
Yes.
and is he your younger brother?
Yes.
By how many years?
2.
You two get along?
Yes. Most days.
Currently, do you get along?
Yes.
Imagine there was some fighting as siblings as you were younger.
Yes.
Where do you work, Ms. Service?
I work at La Crosse Veterinary Clinic.
Do you like animals?
Yes, I do.
Do you have any?
Yep, I have 2 cats.
And you're married.
Yes, I am.
Your husband is Michael Service.
Yes.
For how long have you been married to Michael?
4.5 years.
One child?
Yes.
Daughter?
Yes.
Carlin.
Yes.
How would you describe growing up on East Scotch Cooley Road with Todd and your mom?
We did a lot of stuff outside. They got us a pool, so we could have friends over to do more stuff. We had chickens because I liked animals, and my mom just got us more hobby type stuff to do around the house. So we had chickens and a pool.
Do you have a donkey as well?
Yeah, they're my grandma's donkeys, but yes, we took care of them and visited them a lot.
Okay. Did you have a good childhood?
Yes.
You said you got along with your brother most of the time?
Yes.
Did you get along with your mother most of the time?
Yes.
And your father?
Yes.
You said you had a pool at your home.
Yes.
Did you hear your brother Jordan testify earlier that there was some sort of wood heat for the pool?
Yes.
Did that keep it going later in the season?
Yes. My mom didn't like the cold water, and neither did I, so my dad rigged it up so we could heat it with the wood furnace, so we could make it pretty hot if we wanted to.
Lots of pool parties?
Yes.
Friends from high school would come over?
Yep, we did birthday parties for swimming parties and stuff.
Did you have a job when you were in high school?
I did.
Where?
I worked at West Salem Veterinary Clinic and Old Country Buffet.
Take trips together as a family?
Yes, a lot.
How often?
At least every summer. We'd always go to the Dells several times for the weekend. We go camping a lot.
Did you always have a travel trailer, a camper trailer?
Yeah, for the most part. I think one year we did rent one for Cranfest, but we always made sure we had a camper for Cranfest.
In fact, Ms. Service, did you have a trip planned for the summer of 2017?
Yes, we did.
What was the plan?
We were going to take an RV out west. Again, we had been there previously with our grandparents, and we were going to take my grandma's out there again with Carlin.
When you say we were going to take a trip out west, who do you mean by we?
Me and my husband Michael, Carlin, my mom and dad, Jordan, and my grandma Joyce and my grandma Patty.
Whose idea was it to take a trip out west, an RV trip?
Everybody's. We had been out there before, so we just have a lot of fun out there, so we just wanted to do another trip because everybody enjoyed it last time.
Your mom a good cook?
Yes.
What was your favorite meal that she cooked for you?
Chicken and biscuits.
Remember what your brother liked?
I know what stuff he doesn't like, but I don't remember what he does like.
Would your mom cook for you fairly often?
Yes.
Did you get in trouble when you were a kid?
Occasionally.
How would you be punished by your parents if you got in trouble?
I would just get grounded from my car or having friends over.
Ever remember being spanked?
No.
You remember your brother getting spanked?
No.
Would you coin your childhood as loving?
Yes.
August 2016, the month before your mother's death. We've heard testimony about your parents having been married for how many years at that point?
25 years.
And somebody planned a surprise party.
It was me, but I had people that helped me with it.
Your idea?
Yes.
How many people do you estimate showed up for the party?
Well, over 100 for sure. But we had food made ready. We had food ready and cupcakes ready for over 100 people. So
How'd you get word out to over 100 people without them finding out?
I don't know, but everybody kept their mouths shut, so that was kind of good. I just made a really nice invite on Shutterfly that said it was a surprise, so I could ask everyone to be silent about it.
You and Jordan got together and developed a strategy?
Yes.
Involved a limousine?
Yes.
Was the limousine going to take Todd and Barbara for a ride?
Yes. They were going to go to the freight house, and then it was going to take them back home. But we kind of rigged it up with the driver that he would take them on a different way home to go on a drive. So then they just took them to the log cabin.
Barbara and Todd, your parents often take drives together?
Yes.
So you rigged it with the limo driver to drive them where?
They were just going to go on a different route home, we told them, so that Dad wouldn't know where they were going. So he knows the roads well.
And it worked.
Yes.
They were surprised.
Very surprised.
You said at the log cabin in Bangor is where the party was?
Yep. Yes.
You were there when they arrived?
Yes.
You were there when the limo door was opened?
Yes.
Surprise.
Yes.
How did they react?
They were just very shocked, and they both were crying. We were surprised because we actually surprised them, but
Because it worked.
yeah.
Was your dad emotional?
Yes.
Up until that point, had you seen your dad cry?
Once
When was that?
at his dad's funeral.
So this is the second time you'd seen your dad cry?
Yes.
Okay. If we go forward a little bit to September 2016, where were you living at the time?
We were living on Pierce Street in Onalaska.
You were living with Michael
Yes.
and Carlin.
Yes.
We've heard testimony that that house was being remodeled.
Yes.
Who was doing the remodeling work?
My dad and Michael mostly, and then me and my mom would come in and do like the finishing touches or kind of tell them what to do and where to put things.
So you're midway through a remodel project on the house?
Yes.
Were you working at the veterinary clinic at the time?
Yes.
Do you still work there?
Yes.
How long had you lived in the house at that point?
About 2 years.
And Michael worked where?
He works for Bernie Buckner Mechanical.
That Thursday night before your mom passed. Do you remember that night?
Yes,
Where were you?
I was at their house eating dinner.
Why were you eating dinner? That's the East Scotchcooley Roadhouse.
Yes.
Why were you eating dinner there and not at home?
Because our kitchen was getting remodeled and we didn't have any of our food in there or appliances. Everything was in a box in the spare bedroom so we could renovate it.
Was it typical at this point in your life to go to your childhood home to eat?
Yeah.
Did your mom cook?
Yes.
And is that what happened on that Thursday night?
Yes.
Do you remember, did you work on that Thursday?
Yes.
What time did you work till?
I believe I worked till 5.
And who took care of Carlin?
I usually pick her up from daycare, but she goes to daycare during the day
In West Salem?
in Alaska.
Okay. So did you do as you usually do and pick Carlin up from daycare
Yep.
after work?
Mm-hmm. Yes.
And then did you go where from picking Carlin up?
I went to my parents' house
Any idea what time you got there?
probably around 5:45, 5:30ish.
Do you remember who was there when you got there?
My mom was there. I don't think my brother was there yet, or my dad.
Do you remember how your mom was acting?
She was normal. She always loved to see Carlin, so she was happy.
Did she have dinner prepared?
Yes.
What'd you have?
I don't remember.
Remember what you talked about?
Probably. I don't remember exactly. No.
You said your brother Jordan arrived home at some point.
Yes.
Do you remember speaking with Jordan?
I think we just said hi to him when he was leaving because Carlin goes to bed early, so we were leaving at an earlier time.
Remember saying goodbye to your mother?
Yes.
In the end, that turned out to be the last time you saw your mother alive. Is that correct?
Yes.
The house on that evening, was it as it always is?
Yes. They were prepping the camper for going camping because she has little hampers in different rooms with things that she needs to put in the camper so she can carry them easier.
Did you assist her at all in prepping the camper?
I don't think so.
You were going to go camping with them, right?
We were going to drive up during the day, but the weekend of actual Cranfest we would have stayed with them, but it's hard to keep Carlin up there, so we weren't going to stay with them that weekend.
Did your mother have food set out for the camping adventure?
Yes.
Clothing?
Yes.
All the supplies that go into the trailer?
Yes.
Where did she keep those?
Usually in the spare bedroom. It's kind of by the kitchen just because it was an easy access point to grab everything and store it in one spot.
Your mom seemed excited to go camping?
Yes.
So Jordan arrived back from college. You said you spoke with him only briefly,
Yes.
and then you went home.
Yes.
Remember Michael coming home that night?
No, he was at night school, so I just do Carlin's bedtime routine and then we go to bed. So when he gets home, I'm usually sleeping.
Sleep in the same bed with Carlin?
Yeah,
Were you that night?
co-sleep with her for her first year.
Were you sleeping with her that night?
Yes.
The morning of September 16th, you told us earlier that you work at the vet clinic.
Yes.
What time do you work?
I work at 7 a.m.
So what time would you have to leave home to get to work on time?
Well, I drop Carlin off at daycare, so I usually leave at 6:30, and then I get there at like 6:50, 6:45, or 6:55.
So you dropped Carlin off on the way to work?
Yes.
And did you do so that Friday morning?
Yes.
At some point that morning, you were made aware of an automobile accident, is that right?
Yes.
How?
Well, Michael had called my cell phone a couple times, but I can't keep it on me, so he called the office number, which usually he only calls if he needs to urgently tell me something, so he told me that he couldn't get a hold of them, and that not to worry, but they just were trying to figure out where they were.
Were you concerned at that point?
Yeah, but I worry too much about everything, so I was trying to not worry about it because I didn't think anything could happen. But
What happened next?
some police officers came to my work and told me that they needed to take me to the hospital.
Did they?
I asked them if I could drive my own car, and they went out to their vehicle and came back like 5 minutes later, and they said no, they had to take me themselves.
Did they tell you that there'd been an accident?
No,
Did they ask you questions?
they did not.
Did they drive you to the hospital?
Yes.
Who was there when you got there? Well, let me ask it this way. Was Todd there when you got there?
I think so, yes.
Do you remember how he was acting?
He was just shaking, and just shocked.
Did you ask him what happened?
I just asked him if Mom was okay.
What were you told?
He said he didn't know, and they wouldn't tell him anything about her.
Who wouldn't tell him anything about her?
I just assumed how he had gotten there, that they just didn't tell him anything. I didn't think that the doctors had talked to him yet because he was still trying to get answers from the receptionist there.
Did you ask him any details about the accident?
No.
Did you ask him if he was okay?
Well, probably, but I could see him there, so that was reassuring to me that he was going to be okay.
Did your grandmother arrive?
Yes.
You all waited together?
Yes.
At what point do you remember being told by the physicians or the nursing staff what kind of shape your mother was in?
I just remember, I think he was a neurosurgeon or neuro something, had come in. I think there was two of them. They said that the severity of her head injury was concerning because of the damage to her brain.
They provide you with a prognosis?
Not at that point.
Was Michael there?
Yes.
What did you do?
I got more worried than everyone else because I work with dogs that get hit by car and they have severe head trauma, so I just, with what they had said about the hypoxia and the swelling on her brain, I just knew that it wasn't good.
Were you with your dad the entire time?
Yes.
Did he continue to be emotional?
Yes.
Did you spend the night at the hospital?
Yes.
At what point were you confronted or spoken to by the medical staff again?
They came to talk to us a couple times. They would just tell us, like, we're gonna try this. It's a long shot, but we're gonna give it a try. And then they would just come back, and after they tried that medication, they would come back and say, well, we can try this one more thing if you want us to, and they would just kind of give us updates like that.
Is your father still in a terribly emotional state?
Yes.
Do you believe he had hope?
Yes, he did.
Why do you say that?
Because at one point, when a neurospecialist came back in, he said that if she did recover, she would have need to have someone take care of her 24 hours a day, and she wouldn't.
Hearsay.
Sustained.
At some point, were you told the end was near?
They told us they were going to try mannitol, and I know that for dogs it doesn't usually work. So at that point I knew that that was bad, but still had hope.
In the end, you were told that there was no more hope.
Yes.
Did the close family go in and see your mother?
Yes.
Who was there?
My dad was there, and me and Michael, and I think Jordan came in too.
Did you touch your mom?
Yes.
Where?
I just grabbed her hand,
Remember which one?
her right hand.
See your father touch her?
Yes.
How was he touching her?
He was holding her hand and rubbing it.
What was he saying?
He was just saying,
Objection, hearsay.
Overruled.
does that mean I can say what he said?
You can answer, yes.
He just said, I love you, and that he would take care of my grandma.
For how long did you stay at the hospital?
I think it was mostly all weekend.
At some point, did an employee or employees of the hospital that are tasked with organ donation approach the family?
Yes.
They approach you collectively?
Yes.
Who was present when the organ donation people approached?
My dad and me and Jordan, and Michael might have been there.
You were there?
Yes.
Were you all asked if her wishes were to donate her organs?
They asked us if my mom was a giving person, and we said yes. That she always gave to everyone. She was always saving dogs and animals, and she was always giving to people. And they said, do you think she would want to be giving in her death with organ donation to help others? And we said yes, she would want that.
Did the family ultimately decide then to have her organs donated?
Yes.
Do you know where your father went from the hospital?
He went to my grandma's house.
Do you know for how long he stayed at his grandma's house, your grandma's house?
I know it was a couple days, for sure.
Do you know, did he go home himself in that couple of days at all?
No.
Did you, and when I say home, I mean the East Scotch Cooley Road.
No.
Where did you go?
Michael and I went to our house for sleeping, but we would go wherever he was during the day.
At some point, you were contacted by police officers, weren't you?
Yes.
Where were you when that happened?
I was in my parents' house.
You were asked about their relationship?
Well, they came in and told us we had to get out because they were going to do a search warrant. And an officer told me he had to ask me some questions, so he took me in his squad car.
What type of questions were you asked?
He asked me if my parents argued.
And you
Or-
you responded how?
No.
What other questions did he ask?
He asked if they were having any financial difficulties.
And how did you respond?
I said no.
Remember any other questions he asked?
He tried to ask me what I was doing the night before, but I can't remember what I told him.
Fair to say you have a very close relationship with your father
Yes.
and had a very close relationship with your mother?
Yes.
How would you describe to the jury the relationship between your mother and your father from your perspective?
Absolutely perfect. I tried to model my marriage after theirs.
No other questions?
No questions, Your Honor.
Questions? This time, does any juror have a question of Mr. Mace? See no hands? I think you may step down. We'll take a break at this time, is that all right?
Fine.
Right. About 15 minutes, give or take. We'll talk about the case, and you may step out. The record can show we're outside the presence of the jury. You may all be seated. Is the defense going to call any additional witnesses?
No.
You'll arrest them when they come back in?
Fine.
And you anticipate your rebuttal then?
Yes, we have two witnesses. One is here already. I told the other one 2:30, so hopefully he'll be here soon.
Well, we'll start at 2:35, so that should work out all right. I did have my judicial assistant send you the third draft of the instructions. You can look at that. Let me know when you're ready to talk about them. I have 517 at the very end of it, slightly modified, and we can discuss that, whether it will be given or not at that point. Okay?
Judge, would it be possible, because our printer is not with us today, would it be
No.
possible for your JA to provide me a printed copy?
Well, I'll print out a copy for both sides then. I'll be to a page to save some paper, all right?
Fine.
We'll have that ready in the courtroom here in a couple minutes, but we'll be in recess. You may all be seated. Yeah, the record can show we're back in the courtroom outside the presence of the jury. Anything else either side wants to put on the record before we bring the jury in?
Judge, I would need to renew my motion for directed verdict, considering we're about to rest. I don't want to bring the jury in, rest, and then kick them out right away to renew.
That's fine, that's something to put on the record, so that's good. Go ahead.
The argument about the directed verdict and the renewed motion thereof is, to me, intertwined with why 517 needs to be read. And I don't know if you want me to do this right now, or if you want to do this piecemeal about.
Well, we ask the state, can you argue 517 right now?
I believe so.
Okay, go ahead, do them both.
So when I asked for a directed verdict some days ago after the close of the state's case, the thing I complained about was that the state has not presented a cause and manner of death. They have simply said that the story that Todd Kendhammer has provided is not consistent with what their evidence or their viewing of the evidence suggests. But they've never told us, the jury, anybody else, how they think Barbara Kendhammer was killed. At one point, there was testimony about could her head have been struck against the side of this tire and rim, cause these injuries, cause the death? Could somebody swinging a pipe cause these injuries, cause the death? Could somebody choking cause these injuries, cause the death? Could somebody strangling cause these injuries, cause the death? They haven't told us this is what we think caused the death. That, to me, provides the basis for the directed verdict motion because they've never told us. But as it relates to 517, without a reading of 517, we run the very real risk of the jury going back and one juror saying, well, gee, I think he hit her with the pipe. And another juror saying, well, I think he hit her head on the tire. Well, it doesn't matter. If you think that and I think this, we'll convict. I don't believe that's what the law is. I believe the law is that the evidence, when there's evidence of multiple ways an offense could have been committed, that it's incumbent upon the court to read to the jury that they need to unanimously agree as to how. And I don't think that we have, under these circumstances in this case, I don't think we have that. So all I'm asking for is that 517 be read so this jury is well aware of the fact that they need to be unanimous in their belief or disbelief of the manner and mechanism of death.
And tell me, where does that fit into the first element?
That he caused the death? Because it's causation. It is the first element.
But tell me how that fits into that instruction.
Because they have provided you with multiple forms of causation.
I only heard one through this trial, death by multiple blunt force trauma, if I remember that right. Isn't that not correct?
There was strangulation, there was choking, there was blunt force.
Cause of death was based on blunt force trauma. Am I mistaken on that?
Blunt force trauma can be caused, as the doctor said, by multiple mechanisms. And whether it was the tire or the pipe or some other mechanism, the state has never said. In fact, they've kept the door open to any one of those causation methods.
Okay, Mr. Grinke?
Your Honor, I think Mr. Bednarik is 100% wrong in his belief about what the state has to prove. This instruction not only should not be given, but I think the defense should be kept from arguing in closing that we have to prove something that we are not required to prove. The elements only require that there was a death, that it was an intentional, and that his acts were a substantial factor in causing that death. The cause of death, as listed by Dr. McCubbin, was blunt force injury to the head. The fact that you also might have injuries to the neck, that she may have been strangled, the fact that you also might have injuries to the arms and legs is just relevant to the fact that it was an intentional act. You don't have to describe he hit her with the right hand this time, the left hand this time, a board this time, a rock that time. That would be impossible in almost any case. The jury instruction 517 in the notes starts out by saying this instruction should be considered for use when the defendant is charged with multiple counts and evidence of more than one act is offered as proof of one or more of those counts. That's not what we have here. We have one count. The jury instruction goes on to list a number of times when this jury agreement is not required. One is when bodily harm was caused by the slap of a hand or hit with a board. Similar to this case, we do not have to have all the jurors agree that each injury was committed in one exact way that's unanimous. They do have to consider that there was a beating, that there was blunt force trauma, that he caused it, and that she died as a result. And that's all we have to prove. It would be possible in any homicide case to prove exactly which injury happened in which order to the exclusion of all of the possibilities. It would be impossible in this case to charge more than one count of homicide, and I think that's a good way of looking at this. This instruction, where I see it was given, has been given where, for example, 6 acts of sexual assault occurred. The prosecutor charges one count, and there's a defense to some of the acts but not some of the other acts. In this case, the way the jury instruction would read, that Mr. Bednark is asking for is a defendant's charged with one count of homicide. However, evidence has been introduced of more than one act, any one of which may constitute homicide. That's clearly not the law. We would not be able to charge multiple counts of homicide. This all happened in one transaction, one victim, very short period of time. All the injuries point toward intent and causation of death, and it would be impossible to have a requirement that the state prove jury unanimity on exactly what the order of each and every injury is on her body. I ask that you deny the motion to add this jury instruction. Looking at the notes, I think it makes it clear that all the case law will be on the side of the state in this situation, and also keep the defense from arguing that somehow we have to prove one consistent theory to explain every injury.
Anything else on the motion to dismiss at this point?
Your Honor, I'd repeat what I said already and also repeat the argument I made after the rest of the state's case. I think we've proven the defendant lied about not just what happened, but tried to cover up the crime, and I think the state's evidence was clear that this was a homicide and not an accident.
Mr. Bednark, anything else from you?
No, other than I think 150 stricken testimony would likely be deleted from this.
Well, maybe I'll have to strike something for Mr. Grinke's rebuttal. I haven't taken it out yet, but
Fair.
I sure will if it needs to come up. All right, well, I look carefully at your argument. I think it's 4 pages that were submitted, technically 5, but 4 pages of content. The cases cited, I think, are all distinguishable, specifically Lomagro, Lomagro, does talk about sexual assault like Mr. Grinke brought up, and I think in that particular case there were 3 acts, could be 3 charges. They charged 1, and I can see where unanimity would be an issue with 1 count with 3 different acts that could rise to that. Here we have the 1 death. That's the sole charge, first-degree intentional homicide. It only has 2 elements. First one being the causation. Was the defendant's act a substantial factor to produce the death? And the second one being the intent. And with the intent, the court needs to look at the, not the court, but the trier of fact needs to look at the inferences and subsequent acts and words and statements and all the facts and circumstances bearing upon intent. And that's what this trial was. There was no dispute that Ms. Kendhammer died as a result of some injuries. The state has their theory of the case being that it was because of Mr. Kendhammer. The defense has their theory of the case that it was a result of an accident, and given everything that's been presented here, gives the jury the basis to have to make a decision as to which side is the side they can accept as their verdict. I considered the defense motion to dismiss at the close of the state's case. Now I need to consider all the evidence, and based on what I've seen now, I think that there's still more than sufficient evidence for the jury to, a reasonable jury, to be able to come up with a verdict of guilty at a level beyond a reasonable doubt. And they themselves could, if they feel it's appropriate, give the benefit of doubt to Mr. Kendhammer based on the nature of the evidence, how they view that evidence, how they view all those surrounding facts and circumstances. I think 517 would be highly confusing to the jury. I tried to author it, which is on I think the last page of the instructions I gave you, and it doesn't seem to fit with a 1-count case. I agree with the state that the cause of death was identified as blunt force trauma, as I indicated, to the head. There may be other injuries to her person. Those could be consistent with an aggravated battery causing her death with that blow to the head, or it could be consistent with the accident as the defense contends, but there's still sufficient facts here that a reasonable jury could find, and I don't think that there's a specific act on that they need to hang their hat. They'll find that Mr. Kendhammer had the intent to do acts that would cause her death, or they won't. And if they don't find either element, then he'd be acquitted, obviously. So I will not give 517 and I will deny your motion for dismissal at the close of your case. So, anything else at this point?
No, Your Honor.
No.
Okay. I guess once the state has presented their rebuttal testimony, we'll take another break at that point and see where we're at that point, and if nothing else, I'll give you another copy of the instructions to look at.
And I'll rest on the record when the jury returns.
We will. Okay? Bring 'em in. All right, you may all be seated. At this time, does the defense have any further evidence they wish to offer?
Your Honor, the defense rests.
Very well, the defense rests at this point. Mr. Grinke, does the state have any rebuttal they wish to present?
Yes, Your Honor. The state will call Jared Logan.
Under penalties of perjury, do you solemnly, sincerely, and truly declare and affirm that the testimony about to give in this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
Come over here.
Could you state your name?
Jared Logging,
And could you spell your last name?
Loging,
Mr. Logging, where do you live?
N5603, County Road M, West Salem.
On County M, are you aware of where Bergam Cooley Road is?
Yes,
Would your residence be north or south of Bergen Cooley Road?
south,
And for people who might not be good with directions, that would be closer to West Salem.
closer to West Salem.
Are you familiar with the horse ranch on County M called the Wild Winds Ranch?
Yes,
Where do you live in relation to that?
basically just southwest of it.
Now, do you know somebody named Todd Kendhammer?
Yes,
How do you know him?
I've known him for years through dealings with my brother, his younger brother.
Now, direct your attention to a time in last fall, September 2016. Was there a day that you saw some first responders or ambulances driving by your house?
Yes,
Do you remember if that was September 16th of last year?
I'm pretty sure it was. I was on my way to a chiropractor appointment that day,
What time was your chiropractor appointment?
8:30.
Did you see any first responders or ambulances as you drove away?
As I was entering towards West Salem, I met the first responders heading out towards my house.
What did you drive to your chiropractor appointment?
I drove my car.
What kind of car is that?
It's a little Ford Contour.
Do you also own a truck?
Yes,
What kind of truck?
F-250 Super Duty.
What color is it?
Blue,
Where do you usually park that truck?
in the front yard,
And how close is that to the roadway?
50 yards at the most.
Where you park your truck, are you able to see that truck from the roadway as you drive?
Absolutely.
Had you talked to Mr. Kendhammer about fixing a windshield on that truck in
No.
2016? Do you have two brothers that work at Crown Cork and Seal with Mr. Kendhammer?
Yes.
Are you close to them?
Not really.
Did you talk to them at all about needing a windshield for that truck?
No.
Had you had that windshield in that truck replaced or fixed?
I've had it fixed, yes.
When was that?
That was in 2014 in December. I had, my insurance company took care of it. I had full coverage on the truck. There was a rock chip in it. They fixed it. They had one small rock chip below the wiper that they didn't do, and it's still there.
Do you know a person named Chad Tollefson?
Yes.
Are you close to him?
No.
Did you talk to him in 2016 about needing a windshield for your truck?
No.
In September of 2016, well, at any time in 2016, did you talk to Todd Kendhammer or anybody else about needing a windshield for your truck?
No.
That's all I have.
Mr. Hurley?
Good afternoon, Mr. Logging. Jerry Logging, correct?
Jared Logging.
And do you go by Jerry?
At times, yes.
And do you have a brother Barry
Yes.
and a brother Terry?
Yes.
Is there another brother?
Yes.
What's his name?
Gary.
Okay, if I get mixed up in this, you let me know.
That's why I'm Jared.
Good. You've not spoken with Barry in a year and a half, is that correct?
Correct.
And you've not spoken with your brother Terry in 3 to 4 years, is that correct?
Correct.
You do have a Ford F-250, is that correct?
Correct.
And you say that there was a problem with the windshield, you believe in 2014, is that correct?
Correct.
Do you remember having a phone conversation with an investigator who worked for me, Mr. Raymond DePrima, on May 25th of 2017?
Yes, Ray DePrima showed up at my door.
And do you recall that at that time, you told him you thought the windshield problem was in May or June of 2016?
No.
And do you recall telling Mr. DePrima that it was certainly possible that your brother Barry, who works at Crown with Todd, might have known that there was a crack in the windshield around that time?
At that time, yes.
And you don't work at Crown, is that correct?
Nope.
But both Barry and Terry do work at Crown, is that correct?
Yes.
And you would have no way of knowing whether in a conversation in the lunchroom at Crown, either Barry or Terry or anybody mentioned your name in connection with a broken windshield for a Ford F-250?
Nope.
No further questions.
Anything else, Mr. Grinke?
Just one follow-up. Just to get the timing right, did you have a problem in May or June of 2016?
Absolutely not.
Were you talking to your brothers in May or June of 2016?
No.
That's all.
Mr. Hurley, anything else?
No, sir.
All right, at this time, does any jury have a question of Mr. Logan? At least one? Okay. 539. Five, 3, 9. Hey, Mr. Logan, the question identified as Exhibit 539 is, do you regularly leave your keys in that truck you described?
Absolutely not.
Nothing else?
Okay. All right, thank you. You may step down. Have a good day.
Okay, recall Justin Hine.
Under penalty of perjury, do you solemnly, sincerely, truly declare and affirm that the testimony you will give in this matter shall be the truth, the whole truth, and nothing but the truth?
Mr. Heim, have a seat up here again, please.
Mr. Heim, you testified previously about working at Crown Cork and Seal and knowing Todd Kendhammer, correct?
Correct.
Do you also know his son, Jordan Kendhammer?
Yes.
How do you know Jordan?
He worked summer help for a summer, and we just kind of started being friends, and I helped him work on a tractor that they were overhauling and stuff like that. I did some engine work for him and so forth.
Did you have Jordan Kendhammer's name in your phone?
Yes.
In September of 2016, you remember talking to the police about this case?
Yes.
And did you tell the police about a phone call that you got from Jordan Kendhammer?
Yes.
And was that on September 22nd, Thursday?
Yeah, that sounds about right.
Do you know what time that call came into you?
It was in the morning, or shortly before 9 o'clock, right around 8:50, somewhere around there.
Do you have breaks at work that are normally a normal time?
Normally, usually certain people will take breaks at a certain time. So the whole place is not on break, you know.
At that time, what was your normal, typical break time?
Usually around 8:30.
AM
Yes.
until when?
Till about 9:15, right around there somewhere.
Do you know that this call came in during your break time or not?
Yes.
It did come in during your break time?
Yes, it did, yes.
Did you answer the phone?
No, I did not, no.
Was there a voice message?
No, there was nothing, no voicemail.
Did you call back?
Yes, I did.
Do you know what time you called back?
I finished my break. There is no reception in the building because it's all steel building. So I finished my break, went outside, called back after my break was done. So it would have been right at 9:20, somewhere after 9:15, around there.
Did you leave a message?
I did. I left a message stating that I was at work that day, and I just was wondering what was up. If something needed something, if something was wrong, give me a call back.
Did you ever hear back?
No, I did not.
Before that day, in September of 2016, before that day, when was the last time you would have gotten a call from Jordan Kendhammer?
Been quite some time before that.
And what do you mean by sometime?
Probably months, I would say,
Months?
since probably when we worked on the tractor.
And when was that? Do you remember?
Probably would have been in spring or fall of that prior year.
Of 2015?
I can't positively put a date on when we did the tractor work.
Would it be fair to say at least months before September?
Yes.
That's all I have, Your Honor.
No questions, Judge.
Okay, does any jury have a question for Mr. Heim at this point? I don't see any. All right, Mr. Heim, thank you. You may step down. Anything else, Mr. Grinke?
No, Your Honor, the state rests.
Okay, anything else from the defense?
No, sir.
All right, ladies and gentlemen, I should conclude the testimony at this point. So I'll have you step out for a break of an unknown length. I have to finish up the instructions, and once they're approved, get them copied. I anticipate that I'll give you my instructions up to a certain point today. And then I'll have you back in the morning. You'll hear closing arguments at that point, and I'll give you the end of the instructions. And we'll see where the case goes from there. So step out, don't talk about the case yet, and we'll have you back here shortly. Give me the verdicts. I got one for me. Record can show we're outside the presence of the jury. I will have for you in a moment here what is called draft 4 of the instructions. You can look that over, make sure there's no issues. I'll take that off, draft 4. And then have that copied for the jury if it's approved. And I'm also giving you a copy of the jury verdict I'd like you to look at.
Judge, just to save me a little bit of time, can you tell me what the difference between draft 3 and draft 4 is? Is it just?
Well, I took 150 out. That may be the only issue, but again, if you find any other issues that you may have overlooked, let me know. Have you been able to review the instructions?
Yes, Your Honor.
Almost, 1 second.
Okay. How many exhibits were not received so far? Maybe you just have that list. Is that everything right there? I'll go through that with them, just to make sure that's everything.
I have no.
Okay. Mr. Greinke, any comments on the instructions as proposed right now?
No, Your Honor, I'm not catching any problems or mistakes.
Okay. Mr. Bednarik?
Judge, I cross-referenced the instructions in final draft 4 from the court with Mr. Kendhammer's requested instructions, at least at the outset of trial, and it appears as though all of those that I've requested that remain applicable are being read, so I do not have any objection to draft 4 of the final instructions,
Well,
other than the objection that I'd made previously, but I understand how the
well,
court is
as
ruled.
you know, nobody's perfect. I just want to make sure I don't have typos and other issues in there, so if nobody saw any, I'll go with your comments. All right, we'll go with that. Second of all, the verdict form that I've now given you, if you can look at that. It
I-
does mirror the instruction itself with the exact language, and I do have it highlighted for either guilty or not guilty, so they can make sure they pick the right one. But any comments on that, Mr. Greinke,
No, Your Honor.
Mr. Bednarik?
Yes, Judge, I believe that the verdict should be reversed in that we, the jury, find the defendant Todd A. Kendhammer not guilty of first-degree intentional homicide as charged in the information. I believe that that language should go prior to the identical language replacing not guilty with guilty because he's presumed innocent.
Mr. Greinke, any comment on that?
No.
Okay. Well, that is a correct presumption, but the state has the burden of proving that he's guilty, and that's what, if the state proves their case, then they should find him guilty, and if the state fails in that, then the presumption stays there, and that's what they should choose. I don't see any problem with the order. That's the recommended order, and I'll leave it the way it is. All right. Next, I'm going to go through the exhibits to see if there's anything that you think that should have been received, is not received, so we have that taken care of before the jury comes in. So what I'll do is I'll start with the state. Looks like everything 1 through 18 was received, 19 through 36, 37 through 54, 55, 56, I don't think we're ever,
We did not use those,
So-
Judge.
57 through 72 are received.
Could you hold on just one moment, Judge? You're going a little fast.
We're up to 73 and all were received except for the shoes. 55 and 56.
Except for the shoes.
Agreed.
You caught up?
I am, thank you.
73 through 90, looks like they were all received. 91 through 108. 109 through 126. 127 through 140. Apparently there's a couple missing numbers that weren't even marked. 143 was received. 144. 145 is missing.
We did not enter 145.
I know, it's not even numbered here, so 146, 147, 148, and 150.
So that didn't give me their shoes.
So-
I started here on the back.
Wait, 150 was withdrawn, so that was not received. That's
Correct.
the only one not received. And there's a few, I guess, omitted exhibits.
That's correct from us, Your Honor.
Okay? Is that all right with this defense as far as those exhibits? As far as your understanding?
Yes.
Okay, now I'll go through your exhibits. You ready with those? Okay, I got 200 through 206. 207 was not offered, I don't believe.
Correct.
208 and 209 were received. 210 through 227 were received. 228 through 245 were received. 246 through 261 were received. I got the numbers for 262, nothing there, and then 263 was received. 264, what is that? Is that a received?
I think it might have been part of this.
Yes. 264 through 281 were received, and 282 through 290 were received. So is that your understanding as well?
Yes.
Judge, was there an exhibit 200, or did they start at 201?
200 is the PowerPoint.
Oh, I see, yes. Then we're good.
Okay, and I think your first one was the PowerPoint.
Yes.
All right, then we had juror questions up to 539, which are just part of the record. So, anything else either side want to put on the record before I get the instructions going?
No, Your Honor.
No.
Okay, I assume nobody needs any specific length of time for preparation right now, correct?
Correct.
Okay,
Well, we're not doing closings now, we're just
that's
doing
right.
instructions. Right?
So, okay, we'll be in recess until I get the instructions done. It's going to be at least 10 minutes, probably more like 3:30. We'll be back, and we'll go from there. Okay?
we should
Draft 4.
You all be seated. Right, the record can show we're back in the courtroom outside the presence of the jury. Apologize for the delay. We had some formatting problems with these instructions, and that's what took so long. Anything else that the state wants to put on record before we bring the jury in?
No, Your Honor.
Defense?
No.
Right, I did send you another email through my judicial assistant, the exact instructions I have here, so you can look at them. If you see any errors that something happened because of the formatting problem, I'll fix them in the morning. If we have to give some extra instruction, that would be the only thing I could think of. So you might want to follow along with the other copy to make sure that I don't miss something. If you think I missed it, let me know. I'll tell the jury after I give them the instructions through, I think, page 12, is when they go home tonight, they'll need to pack a bag for tomorrow in case they need to stay overnight, because they will be sequestered. I think we have until 6 o'clock to cancel without penalty. So we'll check with them sometime before that to see where we're at. I'm not thinking I would want them to deliberate much more than 8 hours straight, starting at noon or 1, so they can have a fresh night if it goes that long. So any comments by the state about that?
We can address it probably tomorrow, Judge, but I was thinking to sequester them at a hotel at like 6. They probably can't watch TV or have internet. They might be, I would think we go later here before we sequester them.
We can go later, but we can cancel by 6 if they don't need to.
That was my only thought.
Yeah. Anything from the defense about that?
May I inquire of the circumstances of the sequestration, what will occur?
Okay, what would occur is their bailiffs will be relieved. The sheriff's department would be the ones responsible for maintaining them overnight. I asked that we have a hotel without breakfast so they could all be brought back here in a group, and we'll have breakfast here for them, just like they had lunch. And I'm not sure which hotel they set up. We can find that out from Ms. Radke if you wish to know that, but they would be advised not to look at any news or anything like that, and I'm not sure what they can do about televisions in the room. So,
Well, my inquiry is this. If one can't guard against the use of internet or television or other media, then I'm not sure I understand the purpose of sequestering them.
well, we'll still have their cell phones. Once they go in to deliberate, they won't get their cell phones back unless we allow them to make a call that say that there will be overnight. If they need to do that, we sometimes let them do that. But if you don't want them sequestered, I guess that's another issue.
Yeah, frankly, for the defense, I would prefer that they were not.
Okay, I prefer that when we have a criminal case that it goes through to the end without them being released. But Mr. Franke?
Well, Judge, I also think it's something they might want to discuss more with Mr. Kendhammer, just to make sure that they would be okay with that. I'd be more comfortable if they were sequestered, and I know in the past, we just asked the hotel to unplug the TV and take it out of the room, and they don't get their cell phones, and that solves that problem.
Yeah. So you can talk about it more tonight, see what happens tomorrow. We may not get to it. So I don't know. So anything else?
No.
All right, if they're ready, you can bring them in. All right, you may all be seated. Ladies and gentlemen, each of you have a copy of the final jury instructions so you can read along. And what I'll do is go through about page 12 tonight, this afternoon, and then we'll adjourn for tomorrow to get the closing arguments and then the final instructions beyond that. And I'll give you other instructions about what to do tonight. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The information in this case charges that the defendant, on or about Friday, September 16th of 2016, at Burgham Cooley Road and County Road M in the town of Hamilton, LaCrosse County, Wisconsin, did cause the death of Barbara C. Kendhammer with intent to kill that person or another, contrary to Wisconsin statutes, section 940.01, parent 1, parent A, and 939.50, parent 3, parent A. To this charge, the defendant has entered a plea of not guilty, which means the state must prove, beyond a reasonable doubt, each and every element of the offense charged. An information is nothing more than a written, formal accusation against the defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. First-degree intentional homicide, as defined in section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. 1, the defendant caused the death of Barbara Kendhammer. Cause means that the defendant's act was a substantial factor in producing the death. And 2, the defendant acted with the intent to kill Barbara Kendhammer. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances, in this case, bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. If you are satisfied, beyond a reasonable doubt, that the defendant caused the death of Barbara Kendhammer with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. Evidence is defined as, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. The district attorney and the attorney for the defendant has stipulated or agreed to the admissibility of evidence in this case, consisting of lab reports, photographs, recordings, and other evidence. You will not consider foundational issues with respect to this evidence. You are, however, to consider the testimony with respect to this evidence as you would consider any other testimony. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An evidence received is evidence whether or not it goes to the jury room. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things. First, whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered as evidence. Second, whether the statement was accurately restated here at trial. And third, whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all the other evidence in determining how much weight, if any, the statement deserves. Ordinarily, a witness may testify only about facts. However, a witness with expertise in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any expert's opinion. In resolving conflicts in expert testimony, weigh the different opinions against each other. Also consider the qualifications and credibility of the experts and the facts supporting their opinions. During the trial, an expert witness was told to assume certain facts and was then asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proven. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and of the weight of the evidence. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. The defendant has testified in this case, and you should not discredit the testimony just because the defendant is charged with a crime. Use the same factors to determine the credibility and weight of the defendant's testimony that you use to evaluate the testimony of any other witness. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Remarks of the attorneys are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing each and every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. It is your duty to give the defendant the benefit of every reasonable doubt while you search for the truth. Now, we will pause at this point, adjourn for the evening. Tomorrow morning when we start, counsel, the first job will be to provide their closing arguments or summations, and then I'll give you the balance of the instructions, and we'll go from there. Now, when you go home tonight, again, don't look at any news articles or hear the radio or blogs or internet reviews or anything about this case. Don't talk to anybody about it. Again, try not to think about it overnight, and wait until you are in your deliberations to think about it as you go through the process of reaching a verdict. I don't know how long it's going to take for you to reach a verdict, and I suggest you all bring a little bag with you in case we need to sequester you tomorrow night. We do have a place for that purpose, and we'll see what happens. Tomorrow morning, I think we can start again at 8:30. Is that right?
Yes.
Okay, so we'll be back here again about 8:15 or so, and we'll get going shortly after that, and see what happens. So, enjoy your evening, and we'll see you back here tomorrow morning. Okay, may all be seated. The record could show we're outside the presence of the jury. Since I'm breaking in the middle of my instructions, Mr. Grinke, any comments on the instructions? Did I give them as you thought I would?
Yes, Your Honor.
And the manner in which I gave them, was that acceptable?
Yes, Your Honor.
And Mr. Bednarek?
I agree.
Okay. Just for housekeeping purposes, Mr. Grinke, did you just have a rough idea of your clothing length?
I don't really, hour to an hour and a half is a lot for me, so I'd say hour and a half the most.
That's fine, just want to have an idea.
I think it'll be about the same.
Okay. Well, we'll plan to do a break in between if that's roughly where it is. If you go a lot longer than that, I might need to have you stop. If that's necessary, I'll try to have the jury hang on and let me know if there's a